Chairman. I appreciate the opportunity to be here. Let me first of all say, all 6 of you, I know all about you. You're great guys, and you've served your country, and I have the greatest respect for you. I don't envy you a bit. You're put in a position. I know a little bit about chain of command because I was in a very lowly position, but I was in the United States Army. My chain of command started with my master sergeant and on up to the lieutenants and the rest of them. Yours is the President of the United States. He's the Commander-in-Chief. So you're going to naturally reflect anything that comes from the natural. You have to. You're military, and I understand that. I've been there. What I'd like to do is suggest that maybe after your retirement you might change your mind. I'm looking right now at 24 stars. I just had a few stripes, so I had 24 stars, and that's very, very impressive. And I have a letter here that's signed by 33 stars, but these guys have already retired. They, on this letter, and I want to ask that this be made a part of the record, it says, and I can't read the whole letter, it's not time, but we wish respectfully to challenge the perception that military personnel uniformly support this accord by expressing our strongly held belief that law of the sea ratification would prove inimical both to the national security interests and sovereignty of the United States. It talks about, goes back and gives the history of this thing, and they have very, very strong language, and it's signed by 9 of the top level people who are in retirement. Now, I ask that be a part of the record.
Without objection.
And I also want to make as a part of the record the Reserve Officers Association. This is a letter that was that we have here. It's actually a resolution. At the very end of the resolution, it says, in conclusion, the Reserve Officers Association does not endorse ratification of the Law of the Sea Treaty and actively advocates against it. Historically, the United States has claimed that its right to territory was manifest. To agree to the Law of the Sea Treaty acknowledges that the United Nations has authority over the United States maritime territorial claims. The Reserve Officers Association concern is that the Law of the Sea Treaty will become, and it goes on and on. So I ask also that this be made a part of the record. These are all retired people, and I think that is significant. Now, I'm going to have to quickly go through this. I assume that you all agree, and it can just be a yes or no answer because there isn't time for more than a yes or no answer, that the not signing this is not going to compromise in any way our ability to use force or to navigate. Is that true, or is that yes or no? Do you agree with that? Starting with you, General Jacoby.
Yes, Senator, I agree with that.
All right. Do you agree?
Yes, sir.
At the moment, it will not, but in the future, it could.
Okay.
I agree.
Okay, you all agree? Okay. At the last hearing, I guess here's a guy who's your boss. He's chairman of the Joint Chiefs of Staff, General Dempsey. At the last hearing, he was asked a question as to whether or not this would have an effect. He said, whether failure to ratify the Law of the Sea Treaty would compromise our ability to project force around the world, and his answer that the United States would continue to assert our ability to navigate and our ability to project force, and it would not be deteriorated if we do not ratify this treaty. So I won't ask you whether you agree or disagree with your boss, but I agree with him. When I talk to people in what I call the real world, that's outside of Washington, in Oklahoma, and I say, what do you think about a treaty that cedes our right and to allows another entity to tax the United States for the first time or to sue in a court not in the United States? They find that this is a real sovereignty issue. We've talked about sovereignty up here, but we haven't really gotten specific. I don't think anyone's going to question the fact that this does give the Seabed Authority the right, the privilege, the authority to tax this. And it comes through royalties. Right now, the royalties on the area of the extended continental shelf range between 12.5% and 18.75%. And the reason that's a range is because the oil companies who would drill, they would say anything in excess of that range, we would not be interested in doing. So we have to do it at that range. This authority, according to the U.S. Interagency Extended Continental Shelf Task Force, talks about the resources out there are worth billions, if not trillions. Now, if you just merely take $1 trillion and you apply this to it, they'd be, at the end of 12 years, able to get up to 7% of these royalties that would otherwise go to the United States. Now, that amount would be around $70 billion. I won't ask you the question I asked the last panel because I don't want to put you in that situation. But by doing this and having the authority to tax us in that amount, I'm going to ask, one of the questions I'm going to ask at the end of this, does anyone know of any time in the history of this country that we've ceded our authority, a taxing authority, to allow someone else to tax us? And the second thing would be on which I think Senator Lee is going to, he certainly is much better positioned to talk about the fact that they would be able to sue us. I would only want to read something to make sure it's in the record. When you talk about the people who are chomping at the bit, waiting for us to become a party of this treaty so they can sue the United States of America. One person that I would quote, so it gets into the record, would be the International Tribunal. Well, I don't have it right here, but the Andrew L. Strauss, who was the forum was the global warming emissions. He said the article proposed various forums for initiating lawsuits against the United States, including the Law of the Sea Treaty's compulsory dispute resolution, which I'm sure that Senator Lee will be talking about, mechanisms, and he limited, as the United States has not adhered to the convention, however, a suit could not be brought unless we adhered to the convention. In the book that was written, Climate Change, Damage in International Law, law professor Rhoda Vehemently said she posed a comprehensive hypothetical case that could be brought against the United States for its alleged responsibility in melting glaciers, causing glacier outbursts and floods. The reason I'm interested in this is we in the Senate and the House have refused to adhere to this and pass something that would put a limitation on anthropogenic gases. And here we would be ceding that authority to someone else. So I would merely, and the last thing I want to mention, Mr. Chairman, if you would allow me to do this, they keep talking about a seat at the table. I think my good friend to my right, Senator DeMint, is going to ask, what table are you talking about? Because we already have a table out there, and it's called the International Maritime Organization. And it says their duty, they've had this since World War II. It says that accomplished by passing and adopting, implementing standards, maritime safety and security, efficiency of navigation, and prevention of control of pollution from ships. IMO is the source of approximately 60 legal instruments that guide the regulatory development of its member states and improve the area of the sea. So those questions I would ask are, do you really don't think that our sovereignty is impaired by ceding these authorities to some international group over suing the United States or taxing the United States? And then also, can you tell me of instances where the IMO has not answered these problems that we've been talking about to your satisfaction? Thank you, Mr. Chairman.
Thank you very much, Senator Inhofe. Put a lot on the table. You want to respond, Admiral?
Well, there's an awful lot, and first of all, it's great to see you again, Senator. I always enjoy our conversations. There's an awful lot in that question.
Up to now.
Yeah, no, even now, sir, even now, with respect. There's an awful lot in your question, and I think that we would have to have, a detailed one-on-one discussion, because I'm not sure that I would, for example, agree that it's a tax as opposed to a royalty. I would also suggest, and again, I'm not the economic expert or the industry person who might testify to this, but I think a lot of these guys are not investing in these areas because they're worried that they don't have the underpinning of treaty law to protect them, and so it's money that's not there because they're not drawing the natural resources from the extended continental shelf that perhaps we as a nation would like to see them draw.
But if we did, of course, we would be able to get that royalties in the range that I discussed. And of course, 7% would represent more than 50% of the royalties we'd otherwise be entitled to.
Depending on the range.
That's right.
If we took 18 3/4 and took 7 off of that, we'd be down to certainly 11 3/4, which at the moment that money doesn't exist. So, I mean, we could have a detailed discussion there. Another example would be the Reserve Officers Association letter, which I read for the first time this morning, which I found, after I read it, I felt like these guys ought to go get better advice, because there are a number of statements in there that I think are incorrect or misleading. For example, they talk about territorial seas, that the 1958 Geneva Convention established territorial seas. That's just not true. It talks about, sort of cleverly, that that convention defined international straits. But what it didn't do, but what the law of the sea does, is to define what transit passage is through those areas. That's not in the Geneva Convention. It is in the Law of the Sea Convention. And very importantly to me, and I would want to go into a classified session to discuss this, is that the Law of the Sea Convention defines a stateless vessel. That's incredibly important to us in the counterterrorism world and the counterproliferation world. So there are some inaccuracies in that letter that I would love to sit down and walk through, even though they're a great bunch of guys who obviously mean the best for our country. So again, as I said, I always enjoy our conversations, and I look forward to the potential to have one on this very important subject, sir.
Thank you very much, Admiral. Yes, Admiral Pat.
Yes, and Senator, I lead the U.S. delegation to the International Maritime Organization. I went to my first General Assembly this fall, and in every discussion, bilateral and multilateral, every conversation starts off with the other country questioning and wondering why the U.S. is not asserting leadership by joining the convention. Because every negotiation that's done, whether it has to do with piracy, whether it has to do with marine casualty, overseas, everything is formed on the basis of the treaty. And with us being an outsider, oftentimes just because of who we are, because of the United States, we can influence it and we can still get things done. But it makes it more difficult for us to get these things done. We are looking at this and how are we going to operate in the future, what tools are we going to have to use in the future. And customary international law, countries' influences, they ebb and flow, they rise, they fall. This is something that assures, because it's the basic underpinning of all these treaties, all these agreements that we come to at IMO.
And did you, my question was, where has this not worked in the past? It's been working for the last, since World War II.
Well, I can give you one right now, sir, and it's dealing with the Arctic. I personally requested a meeting with all the other Arctic representatives there so that we can continue our negotiations in terms of coming up with the details of the search and rescue agreements for the Arctic, for pollution response in the Arctic.
They didn't meet with you? Is this what you're asserting here?
They did meet with me, sir, because we are the United States. We still have influence, but
exactly.
Will that influence continue forever? Shifting politics, shifting strengths of countries. What I can tell you is that each and every one of those countries looks to the United States for leadership and setting an example under the rule of law and being in a leadership position. And we are not quite in that leadership position given the current stance that we have.
Do you think in the future, if we do give this opportunity for them to take funds, royalties or otherwise, which I would have to say, Admiral, that's a tax, because that's money, to be redistributed by some organization that we don't even have a voice in to the rest of them, you think that's in our best national security interest?
Well, sir, I think it's all speculative at this point because nobody's willing to drill on the extended continental shelf because they don't have the legal assurances that are given by the convention. And if we are a member of the convention, we do have a seat at the table. Somebody asked, what table do we have a seat at? The International Seabed Authority, where we would have the one permanent seat and veto power. So,
but the same veto power that other countries like Sudan might have. We have veto power, but first of all, you're talking about two entities. One's an advisory and the other is making a decision. And you're saying that we have a different veto power than the other countries have?
We have the power. If any country has the veto power, then that would nullify the ability to distribute any of those funds.
That's right.
So the deal would be that if the if the group does not come up with what seems to be a fair and equitable distribution of those funds, then we would veto it.
On distributing the funds, yes, but the funds will already be there. The tax, the royalty would already be in effect. They would have the control over those funds that came from our efforts that otherwise would be coming to the United States. So that doesn't affect that. They would have that authority. It's just you're saying that we could direct which countries they go to, but they wouldn't be coming to ours.
Some of them could be coming to ours, but you're correct. Whatever the equitable
For the
distribution
record, I
is.
want you to send me a scenario by which any of that would come to the United States.
Well, I'm going to intervene here just
Yeah,
for
you're
a
the
second.
chairman.
Well, no, but I don't want to, I've given you well more than double the amount of time of any other senator, because I really want any opponent to be able to have an opportunity to grill people.
I
here.
appreciate it.
I think that's really important. And I want to get all these issues out on the table. But I do think it's important as we do that, that we try to establish what's fact and what isn't. There is no power and no right of taxation in this document. And we will have an understanding and a declaration that makes it clear in the resolution of ratification that the United States of America will never accede to any other country's tax, that there is no tax in here, and it will be properly defined.
Mr. Chairman, we are saying that they'll have a percentage of the royalties that we would otherwise
A royalty is not a tax. That's correct. A royalty is a bargain. It is an agreement. A royalty is not a tax. No government authority has issued a tax in any kind of way that constitutes taxation. It is a royalty where the companies were at the table during the negotiation. Ronald Reagan set that in place, and in fact, we will have testimony from John Negroponte and others who have been part of these negotiations over a long period of time as to exactly what was agreed on and how. There was a royalty scheme. Why is there a royalty scheme? Because 3/4 of the planet Earth is ocean. 3/4 of the planet. And a whole bunch of countries are landlocked. And if the ones with the border on the ocean have the right to extend their shelf way out into the ocean, you could have very few nations claiming all the resources of the Earth to the exclusion of everybody else. So what was agreed on is really quite minimal. It is far less than the oil companies pay to drill off the coast of Louisiana. Far less. And it is scaled according to how much mining and how much resources you take out of the ocean. Now, Lockheed Martin and a whole bunch of other companies decided, wow, you know what? 97% of something is a heck of a lot better than 0% of nothing. And they want 97%. They want their 93%. And so they've agreed there'll be a scale of some amount that will go to the landlocked nations in compensation for the rights of other countries to exploit the seabed of the Earth. We have over 1 million acres of land out there that we can claim for America, more than any other nation on the face of the planet, because we have Guam, because of the Marianas, because of Hawaii, because of the Aleutians, and so forth. We have the most extensive, and I'll bring a map in of it one day. It's extraordinary. To sit here and think that we're not going to take advantage of that and stake our claim and have our claims legitimate so our companies can go out would be just astonishing. The companies want this. They're ready to pay the royalty because they want the profits that come from the other 93%.
Yes,
now,
they established the royalties. I just have to say, and I'm afraid you'll cut me off before I respond to your
I've never
statement
cut you off, Senator.
about a tax. Money that would be coming to the United States that by virtue of this treaty would not come to the United States, I call that a tax. Most people outside of Washington would call that a tax.
Well,